Today we're looking at the case of the State of Washington versus Modesto Gonzalez. Mr. Gonzalez, with the help of a confidential informant wearing a wire, was convicted of multiple felony charges, including 2 counts of delivering a controlled substance, 2 counts of first-degree unlawful possession of a firearm, 1 count of possession of an unlawful firearm, 1 count of possession of heroin with intent, and 1 count of maintaining a drug property. He's appealing his conviction, arguing the intercept order allowing the wire should not have been granted. Let's get it started.
Good morning. Welcome to the Washington State Court of Appeals. I'm Judge Rebecca Pennell. With me on panel this morning is Judge Robert Lawrenceberry and Judge Laurel Sidaway. The first case on this morning's calendar is State versus Modesto Gonzalez. Counsel, I think you've been informed about how our timer works. Just be aware that the clock ticks down for your total time. The top light is when you're in your primary time. The middle light will show once you go into rebuttal, and the red light on the bottom will start clicking up once you're done with your time. Once the lights are illuminated, it's hard to tell which color is which, so be aware of their location. Counsel for Mr. Gonzalez, if you could introduce yourself and let us know how much time you would like for rebuttal. Oh, and I should add, please mute your microphones when you're not addressing the court, although counsel, of course, can keep them unmuted during their argument.
Your Honor, thank you. My name is Laura Chuang, and I'd like 4 minutes for rebuttal, please.
Thank you. Please proceed.
May it please the court. Your Honors, I represent Mr. Modesto Gonzalez. Mr. Gonzalez was charged with 9 counts in this case in Chelan County arising out of events that occurred in 2017. We raised 7 issues in our opening brief, and the state did concede issues 5B, 6, and 7. We asked the court to accept those concessions. Mr. Gonzalez has also filed a statement of additional grounds, and we request the court consider those issues. And unless the court would like to redirect me on any particular topic, I would like to start by first addressing the sufficiency issues raised under issues 1 and 2 in our opening brief.
I am curious about the issue in the statement of additional grounds regarding the intercept authorization. The statute seems to indicate that there needs to be some case-specific reasons for why an intercept is necessary in this case beyond just boilerplate language. What was or was not specific about this case that would justify an intercept?
Well, Your Honor, that was a pro se filing. I don't have any more information to tell you besides that.
Thank you.
Thank you. With issue 1, the question was whether the trial court erred in finding Mr. Gonzalez guilty of first-degree unlawful possession of a firearm in counts 5 and 7, where the evidence was insufficient to convict. And as this court is well aware, the question is whether, after viewing the evidence in light most favorable to the state, any rational trier of fact could have found guilt beyond a reasonable doubt. And all reasonable inferences from the evidence must be drawn in favor of the state and interpreted most strongly against the defendant. The real question in here, and what we found, is the state failed to prove that Mr. Gonzalez had constructive possession of the guns. Constructive possession occurs when there is no actual physical possession, but there's dominion control over that item, and such dominion control may be immediately exercised. When you look at this, is a totality of the circumstances test. No one factor is dispositive, and control over premises by itself, dominion control over premises by itself, is not enough to prove constructive possession.
Ms. Chuang, can you discuss the fact that the informant indicates viewing the firearms at one point during an undercover transaction? What significance does that have?
Well, Your Honor, if you look at that portion of the record, that's a really good question. The only thing we have from the testimony there is that the only thing the confidential informant, the CI, testified to is that he was with Mr. Gonzalez when he saw the firearms. And that's on page 198. We don't, of the transcript, we don't have any further information about whether or not someone else was present. And there was no testimony about Mr. Gonzalez actually handling the firearms, and looking at the factors, the other factors. This was a situation where the shotguns were found in the basement. They were not found in Mr. Gonzalez's bedroom. There was another person who was known to have lived in the basement at some point during the controlled buys. There were no fingerprints of Mr. Gonzalez found on the firearms, which is a big thing because someone else's fingerprints were found on the firearms.
But aren't firearms typically viewed as being tools of the trade in drug dealing? I would think that an informant or a law enforcement officer merely seeing firearms present during a drug transaction, that would get sort of your hairs on your skin a little bit raised. That, oh, you know, that in itself would seem to be a little bit threatening, just by virtue of seeing them present. So that wouldn't that suggest a connection?
It does suggest some connection. The problem is when you look at the totality of the circumstances, again, there are no fingerprints that match Mr. Gonzalez's on the gun. The testimony was the bare minimum, and the state could have asked further about that. There was nothing else in the record about that. Why didn't the state?
I've got a question about the totality.
Mhm.
I understand that Mr. Gonzalez's mother and his daughter were living in the house with him at the time that the guns were found. Couldn't a jury say, well, we don't believe that the 10-year-old daughter has any relationship with these guns, or the mother, which leaves Mr. Gonzalez, who there's evidence he's doing drugs. Isn't that part of the totality we have to consider?
I would say no. I mean, well, what I would say about that is that we're inferring a lot to assume that just because someone may have been in the drug trade, that they actually possessed guns that were found in part of the home that was linked to. We can't forget the basement was linked to the kitchen, which is a common area, and that there were more than one. More than one adult living in the house, and we at no point claim, of course, that the child would have possession of those guns. But it's important to remember that a third person was recognized by one of the law enforcement officers as having lived in the basement during those controlled buys. So there's just not sufficient evidence to show that Mr. Gonzalez actually could exercise immediate control over those weapons.
Was there any other property that this former tenant of the basement left behind other than the guns?
Your Honor, I don't recall seeing any of that in the record.
Okay.
The former tenant was not living there at the time of the search. Is that right?
That's correct, as far as we know. But again, the testimony by the confidential informant was that he saw these guns down there at some point during the controlled buys. It doesn't indicate when. So, let's see. Again, we just don't, based on our briefing and the facts that in this case, there wasn't sufficient evidence to prove constructive possession of those firearms. And unless the court has any further questions, I'll move on to issues 2. Issue 2 is whether the trial court erred in finding enhancements to counts 3 and 4 and 8, where there was insufficient evidence to prove Mr. Gonzalez delivered or intended to deliver controlled substances within 1,000 feet of a school bus stop. So as the court is aware, a 24-month sentencing enhancement applies under RCW 6950-435 when any person who delivers or intends to deliver a controlled substance to a person does so within 1,000 feet of a school bus route stop designated by the school district. And in this situation, the bare minimum that we have is testimony from an officer where he guessed the distance between the school bus route stop and the premises at 1305 Crescent Street. We don't have an actual measurement in the record. We don't have any, we don't have a terminal point, which when we look at State versus Clayton, which is a Division III case from 1996, that was a key point in that case because this state did not present evidence about where the actual crime had occurred, and there wasn't a distance measurement between the terminal point and the school zone. And for that, yes.
The struggle I'm having with this is that the estimate given was not 900 feet, 800 feet. It seemed to be fairly close. What if the expert said, or not the expert, but the sniper said it was 3 feet away? Is that sufficient?
Your Honor, the point is not so much that, again, it's about the terminal point. There was no evidence presented about the location of the actual crime. And there's no evidence about the size of, and I'd like to add, there's no evidence about the size of the home or the premises at all. How many acres was this? Was it small? Was it large? We just don't know.
But don't you view all the evidence in the light most favorable to the state? And the estimate was, I mean, you could double the estimate and you'd still be well within the distance. So I'm just wondering, are you saying it's just, unless you have a tape measure, I don't care if it's a foot away, it's not good enough?
No, well, no, Your Honor, what I disagree with is when you look at State versus Clayton, the main point again was that the measurement was not to a terminal point. We don't know where the measurement ended up at, and we only have a measurement to the premises.
Did the sniper not give any indication when he was providing his estimate of where he was standing, when he estimated the distance?
No, Your Honor, he didn't. All he said was that he measured the distance between the bus stop. He guessed the distance between the bus stop and the home. We don't know.
I think your argument would be stronger if the drug transaction took place in the Taj Mahal rather than in a rental house, because I think one could surmise that a rental house, average size, perhaps 1,500 to 2,500 square feet. And so, perhaps the officer was off by 50 feet or 70 feet or 80 feet. But again, as Judge Pinnell emphasized, this is a situation where the officer had training about distance and he estimated it's 300 feet. I think your argument would be a lot more, I guess, persuasive to me personally if the officer, the sniper, said that it's 800 feet or 750 feet. But 300 feet seems to be enough. At least we have to give the state inferences on this. I think it's enough, in my opinion. You might want to move on to your next issue.
All right, Your Honor. One more thing I would just like to say: the State versus Jones, also a Division II case, addresses this issue. I'd like to stay my remainder time, if I could. Thank you.
Okay, thank you, Mr. Hershey. You are on mute.
Yeah, you have to scroll toward the bottom of your screen to have the unmute click.
There we go.
I believe I have it.
There you go. We can hear you now.
May it please the court, Jim Hershey for the Chelan County Prosecutor's Office in the state of Washington.
Mr. Hershey, if you could address the SAG issue. I understand Ms. Chuang didn't brief it, but I am curious about the SAG issue with respect to the intercept order. The way I read the statute is there needs to be a particular statement of facts showing no other investigative procedures would work, and so therefore there needs to be an intercept. The case law seems to say it can't just be a standard procedure. It can't just be in every case. But there has to be certain law enforcement needs. So what were the specific circumstances here that would justify an intercept that wouldn't justify an intercept in every drug case?
In this case, number one, with the transactions occurring inside the residence and there not being any undercover officers in the residence, for instance, that would be one factor. And it's a substantial factor, I would submit, as opposed to a more typical controlled buy where the buy is set up, say, in the parking lot of a grocery store, where even though the officers aren't right there with the confidential informant where the transaction's taking place, they nevertheless can actually see the contact. They can see exactly how long the contact takes place. That's a big difference. That's the more typical control buy, where in this case, where it's in a residence, there's more of a need for it. And it makes the conversation that much more important as well.
Mr. Hershey, aren't there also safety concerns when you have a CI purchasing drugs from a potential drug seller? And if you're able to keep an eye on the transaction, law enforcement can help protect the CI. But in a situation where you can't keep eyes on the CI, perhaps that's an additional reason why you need to have some sort of a wire.
Yes, Your Honor, I agree. And that is an important safety factor. And in this case, again, unlike a controlled buy in a parking lot, this being inside the house where there are not eyes on the transaction, it's hearing what's going on. That is a huge safety factor in terms of the need for the recording.
Is it significant that there were firearms viewed? I think the firearms were viewed before the intercept order was in place. Is that true?
Yes. And that was the indication from the CI. So they had those concerns. For instance, I think it's in the record that it's one of the reasons when on the day of the search warrant, officers actually waited for the defendant's daughter to leave the residence to go to school before serving the search warrant. I think that's another indication of the safety concerns and why it's that much more important to have the wire order.
Thank you.
In terms of the sufficiency of the evidence on the first issue addressed, I would submit against the totality of the circumstances. And in this case, the evidence shows the defendant was paying half the rent. He shared the residence, and he not only shared the residence with his mother, but also at the time his 9-year-old daughter. And he testified he was very protective of her. And
Mr. Hershey, he paid half the rent with his mother, right? He didn't pay half the rent with another person. Is that true?
Correct. He paid half with his mother, and he lived there with his mother and his daughter. And he testified he was very protective of his daughter. And that's a piece of evidence from which the jury could certainly conclude that he exercised dominion and control over the residence in terms of picking the place where he hid the firearms and under the floorboards in order to protect his daughter from the firearms and happening to, for instance, to find him on her own. So I would submit, looking at the totality of the evidence, clearly the jury could conclude based on the totality of the evidence that he was the one possessing the firearms. And of course, possession doesn't need to be exclusive. Even for instance, if his mother knew they were there, that doesn't mean he didn't possess them. But when you factor in the evidence of the drug dealing going on by the defendant, clearly firearms are tools of the trade. And when they served the search warrant at the drug dealer's home, they found tools of the trade, not only the firearms, but the scales and the drugs. So I would submit the court should affirm those convictions. As to the second issue and the measuring of the location of the distance between the location of the school bus stop and the drug dealing, I would submit that there is sufficient evidence to convict the defendant. This wasn't a guess by Detective Giacomazzi. He testified based on his experience as a sniper that his calculation of the distance was 300 feet. That was his calculation based on his experience, not just a guess.
Mr. Hershey, oftentimes when we see these cases, we do see, we read that the witness had one of those measuring rollers and has measured the distance from the school bus stop to, usually it is a residence where a transaction took place. And given that I'm just reading transcripts with these, I'm not sure. Are folks going inside of the house and to the exact location where a transaction took place, or is in your experience, are they going to the threshold of the house? Do you know?
It's common for them just to go to the threshold of the house, I know, from what I've read in cases. I can't recall one, for instance, where they actually use the rolling measure device right in, for example, into the house to the bedroom.
It sort of asks too, is where does the drug trafficking take place? Does it take place inside of a specific room of the house? Or does it take place up until the person purchasing the drugs leaves the premises? I guess when you go into a store, you can walk around the store with an item that you've intending to purchase, but it's not yours really till you've paid for it and then leave the store. It raises, I guess, an interesting question on whether or not you have to figure out where exactly the drugs were handed. But is it really a transaction over until the person leaves with the drugs, which would mean it's the threshold? I don't know.
Well, using sort of the court's example, I would suggest that if somebody goes into Nordstrom's to buy something and they pick up an item and they walk around with it, maybe they haven't purchased it at all at that point and they put it down. But when we're looking at the dealer of the merchandise being Nordstrom's, that dealing is going on in the entire premises, regardless of whether a customer might come in and see something right close to the front door and purchase it right close to the front door. They're in the business of selling that retail merchandise everywhere on the premises. And I would submit in this case, the evidence shows that by the fact that were not only drugs found in the defendant's bedroom, and there were scales in the house, in the bedroom, but also there were controlled substances in the coat hanging on the door out in the front of the house. And of course, we have the tools of the trade, the firearms found in the basement under floorboards. So I would submit, it looks like this is a drug property, and it's not just a specific place in the house, but the whole residence.
Well, I think the statute talks about a drug purchase. And so if the issue was presented here and it's not, I would focus on where the purchase occurred in the house, but that's not an issue here.
Okay.
Do you agree on the issue of the terminal location? Do you agree that when the officer testified to his estimate of the distance, he did not describe where he was estimating from?
I would agree with that. However, with regards to the size of the residence and the measurement of 300 feet, if, for instance, this is a typical average rental property, even if you went all the way through to the back edge of the property, I would submit clearly it would still be within 1,000 feet based on the totality of the situation and the evidence in the record.
So this will be known as the Taj Mahal rule.
Next, I would like to go on to the issue of the sufficiency of the evidence on the possession with intent to deliver charge. And I would submit there was not a sufficiency of the evidence, rather, I'm sorry, but the need for a unanimity instruction on the possession with intent to deliver, given that there were controlled substances found in multiple locations and there wasn't an election. And I would submit that this was evidence of a continuing course of conduct, that course of conduct being drug dealing, and therefore, given the situation, there was no need, at the situation and the evidence, there was no need for a unanimity instruction. And
Is there a divergence in the case law between a simple possession case and a possession with intent case? It seems to me that our cases have said in simple possession, different quantities of drugs in different locations are different crimes. And so there needs to be a unanimity. But when you're talking about possession with intent, similar to us discussing the house being like Nordstrom's, it's an ongoing operation within the facility. And so all of the drugs are relevant to the possession with intent. Is that the right distinction?
yes, and it's not only place, but also time at the same time.
Right.
With regards to the allegation that the defendant did not receive the effective assistance of counsel, I would submit that indeed the defendant did, in terms of with regards to the issue of whether or not he was able to be questioned about a prior inconsistent statement. And again, it's the state's position that there wasn't a prior inconsistent statement because what had been said was simply, I don't know. And therefore, it didn't raise an issue of defense counsel having evidence, admissible evidence that he would need to testify. And thus, the state submits he received the effective assistance of counsel. And just lastly, I would mention with regards to the pro se supplemental brief, again, that the order for the intercept was properly entered, and there was a basis for it. It wasn't an abuse of discretion for the trial court to issue the order, and there was no material misstatements based on reckless disregard of the truth or a deliberate falsehood, and that the order was proper. Thank you.
Thank you. Are you submitting at this point, Mr. Hershey?
Yes.
Okay, thank you. Ms. Chuang.
Thank you, Your Honor. I'd like to comment quickly on issue 1 with the rent issue that the state brought up on as far as the totality of the circumstances. Yes, Mr. Gonzalez did pay half of the rent, but again, I'd like to emphasize that there were no fingerprints of Mr. Gonzalez's found on the guns. The fingerprints were someone else's. There was no evidence that he handled the guns, no evidence the guns were stolen or that they were registered to him. And with that, I will continue on to respond one more time to the distance measurement. We look at State versus Jones, which I cited in my brief. We look at State versus Clayton, and they both say there has to be a terminal point. There was testimony in the record from the confidential informant that these transactions occurred in the bedroom of Mr. Gonzalez. And it's improper, I think, for the state to assume the size of the residence or the size of the location of, or the size of the property, even if we don't know, or can kind of assume that it wouldn't be the Taj Mahal. We don't know that. That was not in the record. There's no, there are other cases on this issue where they talk about the size of the home. But I will move on to the Petrich issue, which is issue 4 of our opening brief. And in that situation, we have a jacket that was in the front hallway. Again, we don't have proof of who owned it. There was nothing in the jacket to identify the owner. 2 witnesses testified that they didn't know who owned the jacket. And the fact that there was a heroin baggie in the pocket of the jacket when there wasn't other evidence of possession there was no evidence of possession by Mr. Gonzalez of that jacket. And I would like to direct the court to, it's a case called State versus King, which I cited in my brief, and I'm sure the court has read. But in that situation, there were 2 possessions. There was a rock cocaine possession in a Tylenol bottle that was in a vehicle that was being shared by 2 occupants. And then there was an obvious possession of rock cocaine in a defendant's fanny pack, and the court reversed and remanded because of jury unanimity, because that Tylenol bottle that was found in the car could not be.
But wasn't State versus King a simple possession case, not possession with intent?
That may be. I don't
Because I
don't recall.
I see that there is a divergence in the case law, basically because possession with intent is an ongoing crime. Continuing course of conduct type of thing, whereas simple possession is a discrete acts. You possessed the stuff in the Tylenol bottle, you possessed the things in the purse. Those are different acts. Do you have any cases that you can remember that involved possession with intent?
Not off the top of my head, Your Honor, but I would still again point out there was more than one adult that lived in the home, and that jacket was not identified as Mr. Gonzalez's, and it was in a common area of the home. Really quickly, I'd like to address, if I can, the ineffective assistance of counsel issue. The CI did say at times he had been under the influence. He also denied using drugs during the controlled buys. If you look at pages 200, 203, 206, 205, 208, 211, 216, it's clear that the CI did deny at times that he had been using drugs. So I don't think it's outright concession of memory loss. And I see my time is almost up. So for the reasons stated today and the reasons in our brief filed with this court, we would ask this court to reverse. Thank you.
Thank you very much. I appreciate counsel's submissions and their arguments. It's very helpful. This case will be submitted.
Following these arguments, the court reversed Mr. Gonzalez's conviction for maintaining a drug dwelling. The remaining matters are affirmed and he is held accountable. There we have it, folks. If you like this video, please like and subscribe to see my next video about a drunk driver convicted of vehicular homicide, appealing the court because the victim is an impaired pedestrian. See you next time.